Today's episode is brought to you by Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. So, you've hired a new employee. That's awesome. Have you provided them with a detailed employment agreement? If not, you could be leaving yourself open to litigation, be they a new starter or even existing staff. Lawyer Tracy Myler-Crane has seen business owners in very tricky situations due to poor documentation. Many businesses, she says, provide a one-page agreement with a list of dot points outlining the job role, and that's just not good enough. So, what is needed? Tracy explains to Chris Ashmore.
So in order for it to be a valid employment agreement, it needs to include a whole host of things which meet an employer's legal obligations. So you really need to tell people more than simply what the role is, what the salary is, and some dot points of what they'll need to do day to day. We really need to be focusing on performance and salary reviews and what the framework is for that and how that's going to work. Superannuation. Some employers pay the statutory required amount, others pay more. Some employers allow employees to talk to them about employee contributions, some don't. KPIs need to be set out in crystal clear terms for fairness, because if you ultimately want to performance manage somebody out of your business, it needs to have been clearly outlined what their contractual obligations were for you. And importantly, we need to set out for employees how it is that they can be terminated and what constitutes a serious breach. Those are some of the basics to get started.
Location. These days, with a lot of people working from home, that can be more important than ever.
Undoubtedly more important than ever. The law is always slow to catch up, Chris. So the law still has a legal obligation on employers to provide safe working environments for employees. The law hasn't caught up to how that works when employees are working from home. So the best employers can do for themselves at the moment, until this issue is litigated on, and it will be heavily over the coming years, but the best they could do is set out in an employment agreement, if there is working from home inclusions in a role, what's your working from home policy? What do employees need to do at home? And I'm thinking things like ergonomics, safety, hours, breaks, things like that, because otherwise we can end up in a position where an employee hasn't set themselves up properly and they suffer harm or injury. And the question then becomes, well, who's liable? Who was at fault? So we really need to be addressing some of those things in employment agreements these days. And I'm seeing them in about 80% of the employment agreements that I draft. One of the questions is working from home possible? And the answer is either yes in a hybrid arrangement or yes exclusively working from home. So we need to make sure we've developed these clauses and a policy for working from home.
Can an employer insist that the employee works only in the office?
That's both a legal question and a business question. So yes, they can, in the context of what is the role that is being filled. If you are client-facing, for example, or client servicing, then you need to be in an office, presumably, to see those clients and service those clients. It's just not possible sometimes in some roles to offer a hybrid arrangement or a working from home arrangement. Other times it is. So it depends on the role. When we talk about insisting, there's a lot of discussion at the moment about employers trying to insist on employees coming back into the office after a period of working from home in circumstances where it is perfectly possible for those roles to be performed at home. So then not only are we answering a legal question, but we're answering a business question. Is it good business to force your employees against their will to come to the office in circumstances where they can be happy and just as productive, if not more so, from home? Is that good business? I would suggest possibly not.
Other issues involved with employment agreements include awards and leave entitlements.
We need to make it crystal clear to an employee at the outset how it is they're being paid. If an award applies, what award, and how is the calculation of their salary undertaken? And leave entitlements. Some employers offer the statutory minimum of leave, annual leave, personal leave, carers leave, etc. Others have more generous leave packages, and they need to be outlined in clear terms in an agreement so that you can navigate that with your employees and so that expectations are managed positively from the outset.
Anything else to consider in the agreement?
What I think is becoming more and more topical and important, given the climate that we're all working in, is confidentiality and social media clauses. So privacy is important, and it's something that businesses can't afford to not address appropriately. And outlining in your agreements with your team what their obligations are in respect of confidentiality is vital. So think about things like if you're working from home or working from a cafe and you've got access to business data and client data on your laptop, on your iPad, on your phone. What obligations do you have to respect that data? For example, if you are in a cafe, please sit next to a wall so that people behind you can't look over your shoulder and access personal confidential data. Please don't go to the toilet and leave your laptop open for all to see. Please make sure if you do use an iPad or an iPhone or a smartphone that you have sufficient security and locks in place so that a third party can't innocently or otherwise pick up that device and access data. Things like that. You and I probably think that these things are second nature and go without saying, but in my experience, nothing goes without saying, and we need to say it and we need to include it. Social media is an important consideration as well, given the digital age in which we are living. Do we want our team to be representing us on their personal social media accounts? Do we want our team to be sharing their views on social media in a way that it can be reasonably seen that those views are the views of the employer? Some say yes, some say no. Either way is fine, but it needs to be clearly outlined.
When it comes to roles and responsibilities, how detailed should they be laid out?
If you think about the purpose here, so the purpose for outlining roles and responsibilities is to manage expectations and to be able to manage the relationship going forward. Naturally, the more detail, the better. It'll be easier to manage expectations and relationships if there is sufficient detail so that the parties know what's expected, and then the employment agreement can be a really useful tool for regular performance reviews or performance management if that need arises as well.
Mm-hmm. Responsibilities can change quite quickly though. Does that mean a new agreement needs to be written up each time they do change?
No, it doesn't. But it does mean that the changes need to be communicated clearly. And in my view, my advice to my clients always is to follow up in written form, so an email, outlining what the agreement for the change is, and that email then will form part of the contractual relationship. That said, if the changes are substantial or if there's a lot of changes over a period of time, it can be a good strategy and a good decision to issue an updated employment agreement for the avoidance of doubt and for absolute crystal clear clarity of where people are standing at any point in time.
If nothing changes significantly, though, does that agreement suffice for the duration of the employee's time at the company?
If nothing changes, sure. But my view is that these types of agreements ought to not be treated as set and forget. So they ought to be reviewed at least annually. If there's no changes, at least annually, glance over it to make sure that everything that's in it is still current. If it is, fantastic, you don't need to do anything. If it's not, it's time then for a review, whether that's a performance review and a follow-up email or a fresh agreement if there have been some changes that really ought to be reflected.
Well, there's a lot that's involved within the employment agreement. Is that something that a boss needs to get professional help to put together?
Without doubt, yes is my answer. So as a business owner, we're already wearing all the hats and doing all the things, and we're not experts at all the things. So unless you do have legal or HR expertise, my view is that you ought to engage legal or HR assistance and support to put your contracts together to make sure they comply with your legal obligations and to make sure that you really are adopting best practice and setting yourself up and your team up for success.
That was lawyer Tracy Myler-Crane. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Mazars. To find out more, visit mazars.com.au. That's mazars.com.au.